Leading our discussion is Elizabeth Slattery, who serves as Legal Fellow and Appellate Advocacy Program Manager in our Edwin Meese Center for Legal and Judicial Studies. She focuses on the Supreme Court, separation of powers, judicial nominations, and a variety of constitutional issues. She also manages Heritage's moot court sessions, which prepare litigators for oral argument cases pending before the Supreme Court. Please join me in welcoming Elizabeth Slattery. Elizabeth?
Thank you, John. The Supreme Court heard oral arguments yesterday in the case of Jack Phillips, a Colorado baker who declined to design a cake for a same-sex wedding. The couple filed a complaint with the Colorado Civil Rights Commission, and an administrative law judge found Jack Phillips had engaged in sexual orientation discrimination for trying to run his business in accordance with his religious beliefs. This lengthy legal battle culminated in the Supreme Court taking up the case and hearing argument yesterday. Jack Phillips argues that forcing him to design cakes for same-sex weddings violates his free speech and free exercise rights under the First Amendment. Now the court has heard oral arguments, and the justices will decide whether states can compel business owners like Jack Phillips to create speech that violates their sincerely held religious beliefs. At yesterday's argument, all eyes were on perennial swing vote Justice Anthony Kennedy, who seemed troubled about the state's treatment of Jack Phillips, noting that tolerance is a two-way street. But he also expressed concerns about the dignity interests of the gay community. To discuss how the argument went and what we might expect in the Supreme Court's ruling, we're fortunate to have with us today Jack Phillips' lawyer and two others who filed friend of the court briefs in support of Jack Phillips. In order to get to our panelists, I will keep their introductions very brief. First, we'll hear from Kristen Wagoner. She is a senior vice president and general counsel of Alliance Defending Freedom. She's the lead counsel in Masterpiece Cake Shop, as well as another wedding industry case, Arlene's Flowers, which is pending before the Supreme Court. Before joining ADF, Kristen was a partner at a Seattle-based law firm, and she has extensive experience in civil litigation, employment, education, nonprofit, and constitutional law. She's a graduate of Northwestern University and Regent University School of Law. Then we'll hear from Lloyd Cohen, who's a professor at George Mason University's Antonin Scalia Law School, my alma mater, where he teaches wills, trusts, and estates, statistics for lawyers, and several other courses in applied.
Do you get a new diploma now because it was renamed after you?
No, it doesn't. It doesn't say the actual school's
What if you tell them that you lost your diploma?
Maybe I'll see if I can do that. Before joining the law faculty at the Scalia Law School, Professor Cohen taught at the Chicago-Kent College of Law, served as a special counsel to the U.S. International Trade Commission, and served as a law clerk to Judge Gerald Joflat of the U.S. Court of Appeals for the 11th Circuit. He's a graduate of Harper College, has a Ph.D. from the State University of New York, Binghamton, and a law degree from Emory University. And finally, we'll hear from Ilya Shapiro, who is a senior fellow in constitutional studies at the Cato Institute. He's also the editor-in-chief of Cato's Supreme Court Review. He's testified before Congress and state legislatures and filed more than 200 amicus briefs in the Supreme Court. Ilya's opinion pieces have appeared in the Wall Street Journal and many other publications, and he regularly provides commentary for CNN, Fox News, NPR, and many other outlets. He's a graduate of Princeton, the London School of Economics, and the University of Chicago Law School. Following law school, he clerked for Judge E. Grady Jolly of the U.S. Court of Appeals for the Fifth Circuit. So with that, I'm going to turn it over to Kristen to tell us how the argument went.
Well, the Supreme Court of the United States has recognized that in order to have intellectual individualism and cultural and religious diversity, we have to have the freedom of the mind and the spirit, and that sometimes comes at the expense of eccentricity, even offense. But as the court said in Barnett, that the freedom to differ is so important that it has to be extended to things that matter. And certainly, sex, marriage, and religion matter. They matter to all of us, and they're the foundation upon which we build our families and construct our society. Sexual orientation anti-discrimination laws, though, are being misused right now in a way to silence and punish those who have religious convictions about marriage being between a man and a woman. They serve everyone, but they can't express all messages that violate those religious convictions about marriage. Some of the punishments that these laws impose aren't just the punishments that have been imposed on Jack Phillips, but also jail time. We have clients that are literally facing jail time in Minnesota and Arizona because they won't express messages about marriage that violate their conscience. We have Baronelle Stutzman, whose petition is pending, who faces the loss of all she owns because the court has allowed her to be sued in her personal capacity as well as her business. So the penalties that are able to be imposed under these laws are quite harsh. And certainly for Mr. Phillips, he has not only lost 40% of his income and had his family business placed in jeopardy, but he's lived in fear for the last five years. His wife is afraid to go into the shop. He's received numerous death threats, and his religious beliefs have been demeaned by the government as he's been compared to a perpetrator of the Holocaust, those who would perpetuate slavery, and many, many other names that I will not use today. So I just wanted to kind of elevate to that 30,000-foot level before we dig into Jack's case specifically, because there are a number of cases that are in the lower courts, all of which involve expression, none of which involve a refusal to simply serve people because of who they are, all of which involve expression, and all of which involve one's beliefs on human sexuality and marriage. In terms of the argument yesterday, I would say that Alliance Defending Freedom is cautiously optimistic. I don't think anyone could leave that courtroom and not understand that it may very well be a close decision by the court, as we expected it would be. I think the court asked difficult questions of both sides, and that it really did get to the heart of what these issues are. Mr. Phillips has two claims, free exercise and free speech, and both of them were discussed yesterday in the courtroom. I thought maybe I would just sort of hit some of the high points of our argument. I think that all of those points came out in the course of the argument, but not necessarily through me. So it was a little bit different than how we thought the argument might play out. First of all, for those that were there, hopefully it became clear very quickly that the commission's order, the order that's been imposed on Jack Phillips, requires him not just to create cakes that would be inherently expressive in a wedding context, but actually to use words and symbols and write those words and symbols on cakes even when they violate his deep convictions. And for 25 years, the entire time that Jack Phillips has operated his cake shop, he has always wanted to ensure that his messages were consistent with his conscience. So he has always declined to do Halloween products, any types of custom designs there. He's not done anti-American themed cakes. He's not done cakes that he thought might be vulgar or sexually explicit, no bachelor parties. And he's denied cakes that were celebrating divorce, as well as cakes that were derogatory towards individuals, including LGBT individuals, because that violates his faith as well. So there's a very strong pattern here and consistency that's really unrelated to anything to do with same-sex marriage. In addition, he gladly serves anyone who walks in his store. And when Mr. Craig and Mr. Mullins came into his store, he immediately apologized when they said, we need a custom cake for our wedding. He apologized and said, I'll sell you anything else. I'll make you any other cake that you'd like. I just can't do a same-sex wedding cake. So he wants to serve all people, and he does. A second thing that I would urge for your consideration, which didn't perhaps come out as clearly as we like, I think the test came out, but maybe not as much of an emphasis on the Hurley case and how the Hurley case applies in this context. The Hurley case involved the Boston Parade Association and whether they needed to include an LGBT group contingent in that parade that essentially expressed a self-identifying message. They wanted to march behind a banner with their group's name. The Supreme Court first made a distinction in looking at, is this objection that the association has based on the message or based on who the group is? And the court said, well, we can tell essentially the framework provided was there are two factors here. One is it's a parade, which means that there's an expressive event. Just like there's a wedding, there's an expressive event involved. And the second is they said, LGBT individuals are permitted in this parade in all other capacities, so we can tell they're not discriminating on the basis of class. Same thing is true with Mr. Phillips. He otherwise serves individuals. And Colorado itself, this is very significant, Colorado itself has already recognized the distinction between message and person and how it's interpreting its laws. Third point would be, you heard, if you were there yesterday, and probably if you've read an article today, about the commission and how the commission has played out in terms of the bias that they demonstrated. But that bias wasn't just spoken at a hearing over Jack where they compared his beliefs to perpetrators of the Holocaust and slave owners. They actually put that bias into action. They evidenced it in how they treated 3 other bakeries 3 other bakeries were asked to design custom cakes that only had a religious message, a verse from the Bible, and that verse was critical of same-sex marriage. The Colorado Commission said that that message they could decline because it was offensive and because it was their message. In contrast, they said with Mr. Phillips that it wasn't his message. It would have been the customer's message. They also said they could tell that the other 3 bakeries weren't discriminating because they otherwise served Christians. But yet Mr. Phillips also otherwise serves members of the LGBT community, but that didn't count either. So that's kind of the third big point I think that the court emphasized yesterday was the commission's bias and how it played out in action. And lastly, I'll just end with 2 points regarding respondents' theory and our theory. Respondents' theory hopefully was breathtaking to the court when they look at it closely, because the ACLU and the Colorado government have told the court that in a public accommodation law, they can force speech from filmmakers, oil painters, graphic designers, anyone without really any limit or check on the government's authority under these public accommodation laws. And that's unprecedented. The court's never gone that way before. They also asserted a fallback theory, which was, well, you can only force them if they've used the same or similar words. You may have heard a little bit about that yesterday. But the same or similar words means that when the context changes, the meaning of words changes. And when the event changes, the meaning of the event changes. So, for example, Mr. Phillips, who might design a cross cake for a Presbyterian church, it would mean something very different if he had to do it for an Aryan church, because context matters, and it still compels speech, which violates the compelled speech doctrine. And lastly, I just cite to our theory, which I think is the Hurley framework, and it's much narrower in its application. It provides a constitutional balance that says you need to look at the what, not the who. And what that means is look at the message and not the person. If there is an objection to the message, then we can know that that is not to the person. And we need to realize public accommodation laws apply to millions of transactions that occur every year, millions of goods and services. This application applies, 1, only to people that create speech for a living. That's a very narrow application. And 2, only when those persons have an objection to the message and not the person. So it's a very narrow application that I think is well supported by the court's prior jurisprudence in the compelled speech area as well as in free exercise. Thank you.
Thanks, Kristen. Professor Cohen?
Now for something completely different. Kristen had to try to win a case. I don't. I want to thank my former student, Elizabeth Slattery, for inviting me to participate in this panel. I wear 2 hats, that of a law professor and that of an economist. I need to confess something as an economist. I am here because an old and dear friend, Richard Epstein, was the lead author of an amicus brief in this case and asked me to sign on. As an economist, I economize, especially on my time and effort. When asked to add my name, with all the weight that carries, to public letters or briefs, I gave it all the consideration it deserves. Not all that much. In this case, I saw that, as I fully expected, Richard was on the right side of this dispute, and knowing from experience that I rarely had more than a quibble with him, I relied on the warranty of the Richard Epstein brand name and signed on without further thought. So when Elizabeth asked me to participate in this panel, I thought it prudent that I actually read the brief. I am grateful for that spur, and more generally to immerse myself intellectually in the questions and implications of this case and the jurisprudence that underlies this issue. So though I come out of this intellectual bath wearing the same skin with which I entered, I think I do so with a clearer intellectual view of the question, cleaner intellectual view of the question. When Elizabeth invited me to participate, she wrote that, quote, since Kristen and Ilya will cover the free speech and free exercise issues, I thought it would be interesting to hear from you about how the sky won't fall if some exceptions to state anti-discrimination laws are allowed. I thought, sky won't fall. I want the sky to fall. But let me get to that in a moment. What she had in mind is that the heart of our brief is to counter the risible, fatuous argument of the defenders of the state position and court below that granting exceptions and letting Jack Phillips off the hook would lead to, quote, economic and social balkanization. Balkanization. This kind of rhetoric employed by lawyers is what gives both rhetoric and lawyering a bad name. What this amounts to is the most vacuous, tendentious sort of mischaracterization. What they refer to as balkanization is nothing more than the valuable economic response of market differentiation. All of the best of modern economic life is characterized by differentiation that allows consumers to sort themselves in ways that bring greater satisfaction. Whether it is clothing or cars or dating sites, I've not made use of this last one. My wife won't approve. But I really want to try the one for farmers and ranchers. Merchants market themselves to different consumers, and we all gain by this differentiation. So this so-called balkanization is not merely a feature, rather than a bug of allowing merchants to discriminate among services they offer. It is a virtue. Now, it is conceivable that some forms of discrimination in particular circumstances could seriously burden potential consumers. But that would be the rare exception rather than the general rule. In the case of wedding services for same-sex couples, the claim that such a burden exists is laughable. There are literally dozens of openly gay-friendly websites where merchants affirmatively offer their services. This is true in both states that have statutes like Colorado's and those that don't. And those are merely the merchants that publicly advertise. The state of Colorado offered no evidence that the vast majority of merchants are in any way unwilling to offer their services for same-sex nuptials on the same terms that they would service any other request. So in sum, this claim is pernicious, fatuous nonsense. The very emptiness of this claim by the state of Colorado is a window into the more interesting and important jurisprudential question that underlies this case. I will be sorely disappointed if Mr. Phillips loses this case, but truth be told, I will likely be almost as disappointed if he wins the case, especially on free speech grounds. You see, I expect that, unfortunately, he will win on the narrowest of grounds, that we will be fed a few First Amendment crumbs from the constitutional table and expected to be grateful supplicants in their receipt. My ambition for this case rise much above being a grateful supplicant. I was gratified to see that my friend Richard Epstein snuck into our brief a couple of references to marvelous century-old cases, United States v. Colgate and Truax v. Raich, that embody an earlier view of our Constitution that implicitly treated liberty as baked into the very structure, including but not limited to the Bill of Rights and the First Amendment in particular. Under this view, the constitutional presumption is in favor of liberty over other congenial social and political values. That should hardly be a shocking proposition. After all, we do not have in New York Harbor a statue of inclusion. And the 16th president did not, in his most famous address, refer to this as a nation conceived in giving no offense. And Patrick Henry did not rise in the Virginia House of Burgesses and proclaim, "Give me a safe place or give me death." Rather, all of these major emblematic utterances in our history privilege liberty as a foundational principle. Now, lest I sound like too much of a fanatic, I know, I do, I must emphasize that my position and that of the founders was not that liberty was trump and that it triumphed over all objections. It was rather that it is the beginning strong presumption and that it should and must give way to a compelling state interest. That frequently invoked trope is not empty doggerel. It is meant to have substantial content. Alas, too often in our era, it is invoked as a cant phrase and put to no serious and substantial test. In my view, the High Court should never reach the somewhat arcane question of whether Mr. Phillips's objections fall within either the Free Exercise Clause or the Free Speech Clause. Rather, we should begin at the other end of the inquiry and recognize that Mr. Phillips has a substantial liberty interest in engaging in business as he sees fit, and that the state must first demonstrate it has a compelling interest in interfering with that liberty. That interest need not even be correct. The state may be in error, but it must be serious. And protecting some of its citizens from hurt feelings is not a serious competing interest. The First Amendment rationale, especially the free speech prong, is entirely too narrow and unsatisfying a grounding to find for Mr. Phillips. It perhaps will protect him from the officious intermeddling state, but what of the florist and the caterer? Are they substantially less entitled to decline participating in an event they find objectionable, pernicious, or abhorrent because their contribution is not sufficiently expressive? And even the religious prong is unsatisfactorily narrow and confusing. For what, after all, is a religion? Is it any more than a Weltanschauung? I could go on at length about the difficulties and confusion about what constitutes religion, but time does not permit. Is one to receive an exemption from law only if one can assert a strong contrary religious belief, however idiosyncratic or kooky it may seem? What about people who don't espouse religions, strange or otherwise? What about people who just want to live their own lives? What about people whose objections rest on a worldview or philosophy or culture or instinct that finds these nuptials objectionable? Why is there no constitutional protection for them? It seems to me that our founders had greater respect for individual liberty and the freedom to associate with whom one wished than that. Let me show you what I mean about the core animating logic of our Constitution and its imperatives by drawing your attention to another little discussed clause of the Constitution. So take out your pocket constitutions. What? You don't have them? Very good.
This is the special Shapiro pocket constitution, our names and the date on the back.
Okay. The rest of you, I expect you to acquire them. And turn to the Third Amendment. Yes, there is a Third Amendment. Bet you don't know what it is. Okay. Quartering soldiers. No soldier shall in time of peace be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. See the basic structure? Our constitutional patrimony begins with the liberty of individuals to determine, among other things, who occupies their home as guests or tenants. But in time of war, a compelling state interest, if ever there was one, the fundamental liberty interest can be overridden, but even then only in a manner prescribed by law. So to conclude, it is my hope that at least one justice, Thomas, will see his way clear to author an opinion finding for Mr. Phillips on the basis of something more substantial than First Amendment crumbs. Of course, if it is only one justice, as Arlo Guthrie told us in that folk ballad of the 60s, Alice's Restaurant, the punditry will dismiss him as a nut. Now, if a second justice, perhaps Gorsuch, joins, well then, given the subject matter of the dispute in this case, I won't use the language of Arlo Guthrie as to how two such vigorous defenders of liberty will be impugned. But if a third joins as well, Alito? Well, then I think Arlo is correct. Then we have a movement to reinvigorate our constitutional jurisprudence with the centrality of the liberty interest of the individual citizens.
Ilya?
Well, I'm delighted to be here, mostly because this is while I've spoken at Heritage several times, I've always been invited by Ryan Anderson or David Azarad, and so this is my first time for the Legal Center, which means that finally I get the Mies bobblehead. This has been a lifetime goal of mine. It'll join my pantheon of Supreme Court Justice bobbleheads. I think on the other side I have sports bobbleheads in my office, and I imagine that at night they come alive and war. So. I want to commend Kristen for her presentation today, but more so her presentation yesterday, especially as a first-time advocate before the Supreme Court. It was just an exceptional performance, especially because she got tossed a whole lot of balls out of left field and at least was a very different kind of argument than the moot that I participated in. So she's definitely to be commended. And just kind of having that cheerful countenance on top of knowing the law cold is just really, really impressive. And I go to the court a lot, and I'm telling you, there are a lot of seasoned advocates that don't do as good a job as she did on her first time. Professor Cohen's presentation I found very interesting as well. I thought his brief with my former professor, Richard Epstein, it took me about a decade after I graduated law school he kept telling me, call me Richard, call me Richard. I'm like, I can't do this, Professor Epstein, right? But eventually I started editing his briefs and his articles, and I'm like, yeah, I can call you Richard now after doing that. But it's I commend that brief to you. There are great maps of the locations of bakeries that don't just, refuse, or don't just not refuse to provide cakes for same-sex weddings, but actually advertise that they do so. And there are, I think, 67 that advertise that they do so in the Denver area. The closest one less than a tenth of a mile from Masterpiece Cake Shop. So it angers me. I find myself in agreement with David Brooks's last column, of all people, about how there are legal and there are kind of non-legal, cultural or social ways of dealing with tensions or dealing with slights. And it's just unfortunate that this had to become a case of one kind or another. I mean, the way that we now go about shopping for things, it's not like we randomly go to stores asking for particular products. We go online, and presumably, I think this is how my wife did it when she was shopping for our wedding cake. And by the way, don't let anyone tell you that a cake is just food, because I can tell you, having gone through the process, it's not just about extra calories after you've been served your filet mignon or whatever is the main course. There's clearly a symbol of the the special event and the beginning of your life together, et cetera, et cetera. But anyway, you go online and you look at what kind of things are on offer, where the bakeries are, what they've, sample type of cakes. And surely that's what this couple would have done as well, except they probably got word that this one was run by Jack Phillips, who had certain beliefs, and so they created this test case completely unnecessarily, over-yoking the culture wars, if you will. I don't know what to say about the argument exactly. People were asking me, so what do you think? What are they going to do? I'm like, well, it's going to be 5-4. And they're like, good. Wait, which way? I'm like, I don't know. Asked me to make a prediction. Luckily, I don't get paid by the accuracy of my predictions. I don't think you could do that if you're as a Supreme Court watcher. And by the way, and this ropes in the theme from Monday's argument, you can't go to Las Vegas and bet on it either. The first time I went, I tried. They don't have that. It's perhaps unavoidable that a case as politically fraught as this one would break down on sort of conventional ideological lines, with the four so-called conservatives siding with the baker and the four so-called liberals siding with the couple that wants to use the state's law to compel the baker, and Justice Kennedy somewhere in the middle. But it's nevertheless disappointing, even if it was to be expected. And I think it's especially disconcerting that Justice Sotomayor kept comparing the case to the civil rights Jim Crow era cases, whether Peggy Park involving the barbecue restaurant owner who didn't want to serve black people, or Katzenbach versus McClung came up. That was the Ollie's barbecue. That was really a separate issue involving interstate commerce. And other cases where African Americans were denied service altogether, told that we'll serve you, but you have to stay outside. It's telling that I think over the last number of years, whether before or after Obergefell, none of these wedding vendor cases, or no cases at all, have come before us, at least in the national eye that I've seen, involving businesses that refuse to serve gay people altogether. Jack Phillips certainly has a clientele and offered to sell the couple here, Charlie Craig and David Mullins, anything else that's in his store, as has Barronelle Stutzman, the Washington florist, whose case is very much pending the result in this one. And by the way, this is why I think there won't be a very narrow result that's so specific to this case involving the animus of the commissioners or remand for fact-finding about, their short conversation and whether it really was a custom cake or whether there was lettering, because that doesn't solve the overall issue, which is going to keep coming up and up to the court. And I don't think the kind of political heat is going to go down, so they're not going to be able to avoid it. But regardless, we simply don't have situations like we did in the 60s when businesses claimed both a religious and an expressive right not to serve particular classes of people. That would be an easy case under the law, and we're not, perhaps Professor Cohen and to the dismay of Professor Cohen and Richard Epstein, we're not, and my boss, Roger Pilon, the head of Cato Center for Constitutional Studies, we're not writing on a blank slate. This is not kind of first principles of common law, freedom of association, nor, of course, is it Jim Crow. So the equities fall differently here, but I think the free speech and the free exercise claims are so clear here that you don't even need to revisit that. And indeed, unless a barbecue artist is asked to concoct some sort of meat statue of his tender smoked goodness, there's no parallel here. And that's why we, Cato, wrote in our brief that, quote, wedding and other vendors who produce and sell expressive works must be free to accept or reject particular jobs, but this right does not apply to those who do not engage in protected speech. Creating expressive products is constitutionally different than non-expressive activities like delivering food, renting out ballrooms, or driving limousines. Now, we might want, or there might be, different types of defenses for those kind of businesses, be they statutory or constitutional, but they don't resound in the freedom of speech. There was some interesting discussion by several justices about the significance of being an artist, and is that different from being an artisan? Justice Breyer kind of went on this tangent about, well, there's artisans, they're skilled, maybe they use artistry, but they might not get protection. It was a little bizarre. And then Justice Kagan talked about, what about a makeup artist? It's called an artist. Is that not protected? And I think that's, that kind of semantic distinction isn't really what's driving this. Subway's sandwich shops have sandwich artists, and yet I don't think, unless they're asked to make some sort of tray with some message written in pepperoni slices, I don't think that really conveys a message, no matter how personalized and how many banana peppers and extra red relish you want on your particular hoagie. Perhaps the most interesting exchange to me, I'll get to Kennedy in a moment, but the most telling exchange that I don't think has gotten a lot of press is between Justice Ginsburg and David Cole, the lawyer for the ACLU. And Justice Ginsburg asked, let's see. Let's say Craig and Mullins said, we would like to have on this wedding cake of ours these words, God bless the union of Craig and Mullins. So he would not put that message on any other cake, Cole says, then he doesn't have to put it on that cake. And Ginsburg says, he would put that message on a cake that said, God bless the union of Ruth and Marty. And that was kind of a sweet reference to her late husband. And Cole says, right, if he would say that, if he would put on Ruth and Marty, then he would have to say, God bless the union of Dave and Craig as well. So anyone who's saying that this is not about conveying a message or verbal versus expressive or symbolic, that's not what the other side is actually arguing. Eugene Volokh, who's a UCLA law professor and a prominent First Amendment expert, he and I have filed briefs in several of the wedding vendor cases, the New Mexico photographer, for example, and the Kentucky printer, but we found ourselves on opposite sides of this one, not because he somehow changed his doctrinal views, but because he doesn't think that artisanal cakery is on the line of First Amendment protected speech. It's kind of a debate over that. But we do agree that a line needs to be drawn. And so we've prepared an op-ed, we're pitching it around today, about how the court, regardless, needs to make sure that speech is not, however you define speech and however the court draws that line, it has to draw that line because there's a whole parade of horribles involving whether graphic designers or sculptors or painters or what have you, and a whole host of protected categories. I mean, imagine, does a painter who paints murals for the Obama Library also have to do the same for Trump Tower, regardless of whether the particular jurisdiction has political affiliation as a protected class. Now, as for Kennedy, there was the part about the toleration and tolerance is most meaningful when it's mutual. It seems to me that the state in its position here has been neither tolerant nor respectful of Mr. Phillips's religious beliefs. That's important, especially if Kennedy kind of continues advancing this principle of equal dignity, the equal dignity clause of the Constitution that he has used before and applied it here. But perhaps even more striking is what Kristen alluded to, where he talked about the commissioners on the Colorado Civil Rights Commission. Commissioner Hess says freedom of religion used to justify discrimination is a despicable piece of rhetoric. Did the commission ever disavow or disapprove that statement? And Fred Yarger, who's actually a friend of mine, and I think in his heart of hearts is probably on the other side, but he's doing his job here, says there were no further proceedings. Kennedy says, do you disavow or disapprove of that statement? Yarger says, I would not have counseled my client to make that statement. Kennedy will not let up. This is like cross-examining a hostile witness. Do you now disavow or disapprove that? It's the most unusual thing I've ever seen in an oral argument. So that gives me some hope for Kennedy's vote. And indeed, Kennedy wrote in Obergefell, many who deem same-sex marriage to be wrong reach that conclusion based on decent and honorable religious or philosophical premises. And neither they nor their beliefs are disparaged here. Colorado and the ACLU wants to make this case about bigotry and civil rights, about the next step to equality for a persecuted minority. Well, if we take Obergefell seriously, and I certainly agreed with the result, if not the non-reasoning that got there, then this isn't about bigotry or even whether society has to tolerate distasteful views. But it is a case about civil rights for persecuted minorities, the very few American small businesses that can't bring themselves to support same-sex weddings. More fundamentally, it's about the freedom of speech and conscience and recognizing that the awesome force of government shouldn't be brought to bear on stamping out every last dissenting view. Again, quoting Obergefell, it must be emphasized that religions and those who adhere to religious doctrines may continue to advocate with utmost sincere conviction that by divine precept, same-sex marriage should not be condoned. The First Amendment ensures that religious organizations and persons are given proper protection as they seek to teach the principles that are so fulfilling and central to their lives. The same is true of those who oppose same-sex marriage for other reasons. Fundamentally, there's a difference between denying a service to certain kinds of people and declining to convey a particular message. I don't even know why you'd want to have as your wedding vendor someone who can't, in good faith, literally support your union. If progressives respect diversity, shouldn't they refrain from bending the will of fellow Americans to prevailing pieties? As Justice Jackson observed in West Virginia versus Barnett, the flag salute case from the Second World War, right? We were concerned about patriotism and all that, and the court struck down the requirement that Jehovah's Witnesses kids saluted the flag. He said, quote, freedom to differ is not limited to things that do not matter much. That would be a mere shadow of freedom. The test of its substance is the right to differ as to things that touch the heart of the existing order. It's equally fundamental that the government has no authority to force individuals to engage in expressive acts, if even for a benign purpose. Now, Justice Kennedy could have forestalled some of this mischief by making clear that his ruling in Obergefell protects not just the right to advocate and teach religion, but also to exercise it, and that regardless, people on either side of the debate shouldn't be forced to convey messages they don't agree with. But he didn't. So it's left to the better angels of our pluralistic nature to respect views and lifestyles that we may not like. And I hope that Kennedy sees it that way. Certainly, if the only people happy with Kennedy's opinion, as in Obergefell, is Cato, I obviously would love to live with that. And I can imagine the last day of term. My birthday, by the way, is June 27th. I haven't looked, but often big Supreme Court cases come down on my birthday, and I think it would just be great if Kennedy announces a victory for Masterpiece Cake Shop, celebrating both the freedom of speech and toleration and gay rights, and then promptly retires, kind of a mic drop moment. We shall see.
That would be a happy birthday indeed. Thanks, Ilya. So before we open it up for questions from the audience, I was wondering first if you guys have any reactions to anything other panelists said, and if not, I've got a few questions for you. No reactions? Okay. So Solicitor General Noel Francisco had divided argument time. And he described this case as the flip side of the Hurley case that Kristen mentioned. And this was where the court said that a state couldn't force a parade to include a particular speaker. So he says this is the flip side, and that the state here is forcing a speaker to join a parade that he doesn't want to be a part of.
Yeah, the full line that he used in the moot, which is just excellent, and I've stolen a couple of times in media commentary. If you can't force a parade to include the speaker, you can't force a speaker to join the parade.
Yeah. So how did the justices respond to this argument?
Well, I think it's hard to know. I mean, I was surprised that the Hurley line of cases didn't play more of a role in the argument. They certainly did in the moots. That's what, we were focused on, and the Solicitor General is convinced that Hurley is the right case, and I think he's right. That Hurley actually says that the Massachusetts government made the parade the public accommodation. Rather than the association, they made the expression the public accommodation. And the same thing is true with the cake. They're making the wedding cake the public accommodation and forcing the government to intrude into the freedom of the mind and spirit. So I think the Solicitor General was spot on. Hopefully the court has just given it so much thought they didn't feel the need to discuss it.
Yeah, there was very little discussion of precedent in general. The first, Kristen's part of the argument was all assorted hypotheticals, and then on the other side, with Yarger, it was a lot of religious free exercise and the animus of the commission, and then with Cole, it was kind of, there wasn't, how do we distinguish this? Or is this more like Hurley than fair? Or, what role does O'Brien play? Each of the cases kind of, I think, got mentioned like once, but it wasn't really a focus on that, which is not necessarily surprising because it's all over the briefs and they want to get out and argument certain things that aren't in the briefs, work out certain theories or hypotheticals or what have you. But yeah, it definitely was not a doctrinal argument.
So Justice Kagan asked a lot of questions about line drawing for your side particularly. If making a wedding cake a speech, what about hairstylists, makeup artists, jewelers, tailors, many others? So what do you think is the line that the court should be drawing, and do you think any of the liberal justices were persuaded by this?
I don't want to speculate on whether I'll let you. I think it's more appropriate for you to speculate on that. I can talk about the line drawing.
Well, look, it clearly just comes down to Kennedy, and he's going to have that. Look, if he treats his own opinion seriously, that you can be against gay marriage and not be a bigot, then I think that's fine. And he cares very much about animus, right? So he reaches a lot of libertarian results, not because he's a classical liberal, but because he has this view. I think I've written over times. I'm trying to systematize his thinking. I have a couple articles titled "The Once and Future Swing Vote" and "The Sweet Mystery of Anthony Kennedy." He sees himself as that kind of civic-minded burgermeister, where a kind of a noblesse oblige feeling, where a tolerant, civilized society would not allow the demeaning and disparaging of certain classes of people. So it's not that it's a libertarian view about individual rights and liberty, but it reflects poorly on society if we impose certain rules and demean people in certain ways. We meaning the government. And so I think it's perfectly natural for him to write an opinion saying, I was serious in Obergefell, those passages that I just read. And here, the Bakers might take offense, but there are slights in daily life, but ultimately that's much smaller than forcing someone to convey a message that they disagree, or forcing them to violate their religious principles, that sort of thing, especially when the government comes at it with the view that, well, he must be bigoted.
And I don't think the line is hard to draw. My hope is Justice Kagan was just sort of trying to tease it out. But the idea that makeup artistry is speech, when you compare that to the court's prior precedent, the court looks at whether something's being communicated, and it is a very low bar. When I look at a Jackson Pollock painting, I have no idea what he's trying to communicate. It looks like he's just spray painted something on a portrait. Or when you look at sculpture, many times we don't have any idea what the artist is communicating, yet the court would say that that's protected. So it's a very low bar. It's whether it's analogous to other protected mediums when the court's considering a new medium like cakes, and that's what it used in the video game case in Brown. So, I think we're on the right side of the line with cakes, but the suggestion that somehow, makeup artists and just general caterers, that to me is a little bit of silliness.
Yeah, the court draws these lines all the time about what's expressive and not expressive, and I think Noel Francisco got it right that cake baking, wedding cake baking, is like sculpture, but using fondant rather than plaster.
All right, we're going to open it up for questions from the audience. So please wait for the microphone, identify yourself, and if I don't hear a question mark coming after the first sentence, I'm going to cut you off. Any questions? Back here.
So obviously Jack's case focused a lot on freedom of expression, and I'm wondering, regardless of how the court resolves Jack's case, or potentially in view of how it does, whether similar cases that focus more on freedom of association might crop up. So similar circumstances, but less of an expressive medium involved, more just the question of, do I have to associate with this event?
Who would like to take that?
You spoke about freedom of association.
Yes, well, based on this particular line of dispute, that would end up being a loser. That's why I find it really very unsatisfying to root this in the First Amendment, in these particular clauses of the First Amendment, and that's why I was arguing for we have to go back 100 years to a more vigorous understanding of our freedoms of association and liberty more generally. And this is just an accident in this case that we're able to say, the cake is an expression, when the whole event is an expression. And have to look at the other end of the line. So I wouldn't be optimistic with this court that that someone who simply didn't want to associate would win such a case.
Their brief, the Law and Econ Scholars brief, makes really good points about all of this. And the thing is, we have this Jim Crow filter over everything, as if either we impose the Civil Rights Act always, forever on each case, or we do nothing and the market takes care of it. And that's not how traditional public accommodations law under the common law meant. It's not like before 1964 or 65, anyone could refuse anyone else for any reason in any circumstance. Original public accommodations law was protecting travelers in England, and it referred to innkeepers. I mean, you had very few public shops, as it were, but public accommodations were inns, which were a combination hotel and restaurant, I suppose. And if the traveler were denied service, then he would literally have to travel another day to find the next place. And that was unreasonable. And so all these doctrines came up that, yes, you have to serve, but the traveler has to pay a reasonable rate and all of these sorts of things. It was almost like a natural monopoly situation. And that's different than Jim Crow, where not only did you have a social and cultural reinforcement of a particularly benighted view of one particular racial group, but it was state-supported. The segregation laws required that restaurants and hotels, and it was primarily about restaurants and hotels, not about bakeries or custom ordering, whatever. The real concern was, could people eat? Could people go about their daily lives? I suppose facilities, bathrooms, that sort of thing. The public accommodations in its common law sense. And I think you did need the Civil Rights Act to come in and break that up. But you don't need that in every circumstance. And their brief talks about how nowadays, if you're Jack Phillips, you actually lose business by saying that you won't serve or you won't participate in certain types of things. If you put any kinds of restrictions that are politically correct. Support for same-sex marriage is a majority position in this country, and so wedding bakeries or other vendors gain clientele, even straight clients, by advertising their gay friendliness. So this is not someone doing this out of that kind of monopoly situation. This came up minutely in oral argument where Justice Sotomayor talked about army bases, military bases, and what if there is only one, they're in remote areas, not all of them are, but if they're in remote areas, and there's only one or two bakeries around, and they share a more kind of conservative religious orientation that a lot of military areas might, what happens then? And the answer is, well, in that kind of natural monopoly situation, you might have to have some sort of restrictions and regulations. And indeed, on Army bases, we have restrictions of freedoms of all sorts. Even if it's not a military bakery per se, but hard cases make for bad law. But that's the exception to the general understanding that freedom of association could very well work.
What he said.
Down here.
Thank you. Kevin Daly, Daily Caller News Foundation. My question is for Ms. Wagner. I'm wondering if you were surprised that the SG entered this case as an amicus, and if you were happy to split your oral argument time with General Francisco, and what you saw as the federal interest in this case.
I was happy to split my oral argument time. He's a very distinguished lawyer, and he's stood for many great causes in the past, even before he became Solicitor General. I wasn't surprised that the Department of Justice came in, because I think that that's their job. I know that this administration is very invested in protecting the free speech rights and free exercise rights of all Americans, regardless of their faith and regardless of their political persuasion. And that's the principle that the General was arguing for.
I always find it. Sorry, do you want to comment?
No, go ahead.
Just a side note. Whenever I hear general, the use of general for attorney general or solicitor general is just bizarre. I would have thought that John Roberts, being a grammar stickler, would have gotten rid of that, but he just enhanced it. But just hearing General Francisco, it reminds me of the old, General Francisco Franco is now dead and still dead. Saturday Night Live. This goes over the head of all you millennials in the audience. But
We won't tell Noel Francisco about that. I think we have time for one more question.
Hi, Hans von Spakovsky, Heritage Foundation. This was not directly at issue in the case, but every time we hear about one of these state civil rights commissions that have been created in places like Colorado, it's because of an abusive case, one where they have imposed huge administrative fines, or driven somebody out of business. I wonder whether, do you all think there's going to be any kind of backlash that might cause state legislatures to rethink giving a state agency this kind of power?
I hope so. I think that we've seen a bit of a backlash in terms of states that are willing to even consider these types of laws, because now we actually have victims. We're seeing how they're being played out. And frankly, when our clients have been asked by legislators and local municipal bodies to come in and testify, it usually turns the tide, because when you're able to present them with a real person that has been subjected to this kind of grievous harm, it helps open people's eyes on what are we really trying to protect here, because access is not an issue.
I don't know about, I guess you don't hear about the states that, or municipalities that don't pass these laws, and where these kinds of efforts are, the backlash is having an effect. In terms of reversals, there was actually a reversal in Canada. They had a human rights commission that was going after all sorts of weird things, and eventually they repealed the law that authorized it at a federal level. Some of the provinces still have them, but I don't think it's a done deal.
One other argument that was made in the briefing, which I thought was rather interesting, was using this case and perhaps appealing to Justice Kennedy to say, if you really think these protections are important, then you need to protect the dissenters, because state legislators and local government bodies are going to be less inclined to adopt these unless you protect them. So I don't know how that played with them, but it was an argument raised in the briefs. Also, I just want to add on the expressive association thing, Chief Justice Roberts did bring that up yesterday in the distinction of whether someone needs to sell something that they've already made but will be used in a way that violates their conscience. And so certainly in that case, there could be an expressive association claim there, but I think we need to work on developing that body of law. It's not a test I think you would naturally prevail under at this point.
Well, we've come to the end of our time, so please join me in thanking our panelists.